Welcome to Civics in a Year, the podcast that makes civic literacy fast, accessible, and surprisingly engaging. In just 10 minutes an episode, we'll tackle one of 250 essential questions about American democracy, how it works, why it matters, and what it means for you. Whether you're a student, a teacher, or just someone who wants to better understand your country and your rights, you're in the right place. Civics in a Year is powered by the Civic Literacy Curriculum from the Center for American Civics and is produced in partnership with the School of Civic and Economic Thought and Leadership at Arizona State University. Welcome back to Civics in a Year. Today's Supreme Court case is Brown versus Board of Education. And there's actually, again, two decisions, and we're going to talk about that. But we have Dr. Bienberg back with us. Dr. Bienberg, tell us a little bit more about Brown versus Board of Education.
Right. So as you noted, there's two cases, and if you want to think about it, there's actually sort of a pair of even additional companion cases that are worth talking about. So the backs, obviously, in a previous podcast, we talked about the Plessy v. Ferguson case and sort of the implication on that, sort of giving the green light for the creation of Jim Crow. And at the sort of core of that ends up being school segregation. And over the course of the 30s, 40s, and 50s, the NAACP and other critics effectively are trying to pick at that regime. And they use a very, very smart legal strategy, which is they originally try to go after the equal part. And they say, basically, even if separate but equal were true, the black schools suck. Like they're terrible. And so quite interestingly, some of the more perceptive Southerners actually realize what's happening here. And so ironically, you have this movement by a wing of sort of progressive Southern Democratic governors to massively expand the funding into their schools in order to basically forestall this. And the leader of this movement is the governor of South Carolina named Jimmy Burns. Jimmy Burns is basically a name who's kind of forgotten from history today, but Burns had been one of Franklin Roosevelt's absolutely closest advisors. In fact, he's appointed to the Supreme Court at one point, but he finds it super boring. So he quits and he ends up, yeah, you're laughing, but it's true. And he ends up effectively, as the terms are sort of fuzzy, but effectively almost the domestic czar of the United States' economic policy during World War II, while Roosevelt is focusing on sort of the foreign policy side. So this is not some like marginal Yahoo. Like this is effectively Franklin Roosevelt's right-hand man who then goes to become governor of South Carolina. And so the Brown case is sort of spooling up a few times. They hear re-arguments. Some of the states are starting to pick at this. Arizona, for example, using its own Arizona state constitution, actually deems school segregation unconstitutional under the Arizona Constitution, and that's something we should do in a separate podcast, I think, on another thing. But so this sort of conflict is becoming clear that school segregation is becoming increasingly, and segregation more broadly by government institutions, is more and more seen as in tension with the 14th Amendment. Originally, they argue the case under Chief Justice Fred Vinson, who is, again, former Secretary of the Treasury for Harry Truman, so fairly major figure. Much more common to appoint political people to the court at the time. Vinson dies, and this is not relevant to Brown v. Board of Education, but it's a history story that I just can't resist. Vinson is not very popular with some of his fellow justices, and some of them are also afraid he's going to make Brown go out the wrong way. And so literally at his funeral, one of the justices turns to the other one. This is Felix Frankfurter. I can't remember which one he's talking to. And he says, basically, Vinson clocking out is the first evidence I've ever seen of God in my life. At the guy's funeral. So
wow.
Yeah. So Vinson gets replaced by Earl Warren.
Mm-hmm.
Earl Warren is very, very keen on seeing the destruction of segregation. There are some who've argued this is a sort of atonement for him, because when he was governor of California, he was one of the, if not the chief architect of Japanese internment. Warren basically gets appointed to the Supreme Court in a quasi-corrupt deal with Dwight Eisenhower, which is he'll back him for president at the Republican convention if Warren gets appointed. That whole backstory is to say there's a lot of actual politics happening here with Brown. It's not just a legal issue. So they re-argue the case a couple times, and Jimmy Burns, the governor of South Carolina, it's easy to forget. There's a companion case that's tracking along with Brown, which is a consolidated. So Brown is from Kansas, Topeka, Kansas, right? There's a case called Briggs v. Elliott from South Carolina, and the court merges the two of them. But Burns is the one who basically takes care of the core of basically he hires the best lawyer in the entire country to argue in the defense of the constitutionality of Brown. A guy named John Davis, who had been Woodrow Wilson's Solicitor General and then a member of Congress and then Democratic 1924 presidential nominee, like big player. So the Brown case, they re-argue it a couple of times because they're kind of buying time. And then the case comes down. And the striking thing about the Brown case is that when I assign my con law cases, I usually edit them down really ferociously because like the Dred Scott case is like 250 pages and I'm not going to make them read that. Brown is not, I edit a little bit, but it's very short because Earl Warren very consciously has the idea. He says, I really don't care what the law professors and the historians are going to think about this case. I want this to be short and simple so it can be printed in the newspapers. And so in some ways, this is a little harsh, but Brown 1 is closer to an op-ed than a legal opinion in many ways. Like, for example, the discussion of does the original understanding require this? He effectively has like a one-line footnote where he says, like, it's complicated. Who cares? Like, normally you would then have a bunch of citations and long evidence and a big thing, but he just basically says, like, it's hard because he knows that the law professors are going to care about that, but nobody else is really going to care about that. And so what he argues is effectively whatever the understanding was at the time of the 1890s, whether separate but equal could be equal, he says, really, we have seen and understand that it just functionally can't be equal. Even if Burns and crew sort of spend all the money and hire the same quality of teachers in the same kind of buildings, they're not, even if that's happening, the sort of aggressive stigma of designing a system to say you are unworthy of being in a school with us is itself unconstitutional under the Equal Protection Clause. And so, but again, Earl Warren is trying to minimize conflict. And so he doesn't want this to get picked apart. And so then the next question is, okay, it's unconstitutional. Now what do we do about it? And Warren says, we'll come back and argue that later. And so that's what Brown 2 is. So they come back effectively in the next term, and then they say, yep, indeed, school segregation is unconstitutional under the 14th Amendment. And then they kind of punt again, and they put the lower courts in a really tough bind because they don't give a rule. They just say lower courts should work to eliminate segregation in schools with all deliberate speed. Does that mean 6 months from now? Does that mean 2 years from now? Right. So then the district courts effectively. So this is with Southern federal district judges are like really underappreciated heroes in American history because they're the ones getting really, I mean, there's, signs coming up criticizing Earl Warren. They're the ones on the ground that are trying to implement this, both the district judges and then the circuit judges. And so again, the Brown case, Brown 2 is also pretty short. There's a little concurrence by Felix Frankfurter, but it's effectively, again, pretty short. There's also a sort of another case that's worth flagging, which is called Bowling v. Sharp, which is the sort of companion case in dealing with federal territories. Washington, D.C. is not bound by the Equal Protection Clause, which by its terms applies to states, right? No state shall deprive anyone of the protection of the laws. And Earl Warren basically says, but the Due Process Clause does. And if we think about sort of due process, being treated fairly under the law is part of that. When this case comes down, obviously, Southerners in some places are furious. Some of them, they take it a little better. Some places do massive resistance. State of Virginia basically closes their school system and says, fine, we won't have a public school system. There's really aggressive pushback in some places. Again, some of the states, they sort of grumble, but sort of suck it up and start implementing it. North Carolina, I think, is generally regarded for sort of being more agreeable to it. And so there's a series of follow-ups in future years, Cooper v. Aaron and others, which is Dwight Eisenhower effectively has to almost militarily implement this in Arkansas against Orville Faubus. So Brown doesn't get aggressive in terms of like percentages of school desegregation. It takes 8-10 years. Historians have tried to argue, in fact, it's Congress that really ends up sort of putting the implementation on this in terms of actually making it stick. But Brown very clearly sets out the precedent that basically legal discrimination on racial grounds in education is unconstitutional. And law professors have gone through, it's sort of a cottage industry to basically say, and there literally was a book actually about 15, 20 years ago, maybe, called What Brown v. Board Should Have Said. And it's various law professors going through and saying, based on this constitutional methodology, here's how Brown would have come out. Based on this one, here's how it should have been argued. And probably most famously, the originalist scholar Michael McConnell has argued, if you look at the sort of debates about the elections at the time and congressional bills afterward, that indeed this is faithful to and required by the original understanding of the Constitution, even if Earl Warren just sort of shrugged his hands like, boring con law. So for folks that really want to dive into sort of the legal argument on that, there's a very, very rich historical record that scholars have put together. But the Brown case itself really is very short and sweet and just basically school segregation is unconstitutional, period. We'll come back next time and tell you how to get rid of it. And then they come back next time and say, lower court judges, you guys figure it out. But Brown obviously is sort of it's hard to say like what the first shot is. Is it desegregating the army? Is it, you can work back. But Brown clearly does stand for the position that the United States government will finally implement sort of the anti-racial discrimination provisions of the 14th Amendment that have been sort of left for decades. And then Congress will sort of get on board later on with the Voting Rights Act as an enforcement of the 15th Amendment and the Civil Rights Act, particularly the provision on public accommodations in dealing with the 14th Amendment's guarantee of equal protection.
It's such an interesting thing that the lead lawyer in this case was Thurgood Marshall, who then becomes a Supreme Court justice, and just how intertwined, a lot of these things are. So, Dr. Meinberg, thank you so much, and I look forward to our next case.
Thanks for joining us on another episode of Civics in a Year. If you enjoyed this episode, be sure to subscribe and share it with someone who cares about a constitutional republic as much as you do. For more episodes, resources, and updates, follow us on social media or visit us at civics.asu.edu. Make sure to check out the show notes for any relevant links. Special thanks to the United States Marine Band for their performance of the Stars and Stripes Forever. Let's keep building a stronger constitutional republic, one episode at a time.